Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. This morning, you're here for our arraignment docket. And basically what the arraignment is, it's an opportunity for the court to tell you or inform you as to what you've been charged with, what your options are, and the rights that you have regarding your case. We handle class A and B misdemeanors in this court. So I simply said that just to inform you that the case that you have in this court is not a felony. We do not handle felony cases here. So we only handle class A and class B misdemeanors. Now, obviously the difference between the two, between a felony and a misdemeanor is misdemeanors are what we call our most serious cases. Our felony offenses is what we call our most serious cases, and our misdemeanors is not commonly referred to as petty cases, although they are serious. Now, the types of cases we handle here are classified either as a class A or a class B misdemeanor. If your case is a class A misdemeanor, the range of punishment for a class A misdemeanor is confinement in the county jail for a term not to exceed 1 year or 365 days. A fine not to exceed $4,000, or you could be given both such fine and confinement. If you have a class B misdemeanor, then for your class B misdemeanor, the range of punishment is 180 days confinement in the county jail, or you could be given a fine not to exceed $2,000 or both such fine and confinement. So therefore, if you have a class B misdemeanor, you could be given time anywhere from 0 days to 180 days. You could be given a fine from $0 all the way up to $2,000, or you could be given both such fine and confinement. Class A misdemeanor, range of punishment, you could be given jail time or confinement from 0 days to 365 days, which is a year, or a fine from $0 to $4,000, or you can be given both such fine and confinement. Now, you have a right to have an attorney. On the arraignment, you have 3 options. Your first option is you may hire an attorney. Your second option is if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Or number 3, you may represent yourself. Now, if you want an attorney to represent you and have enough money to hire an attorney, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. Be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, you may change your mind at any time and may request counsel from the court. Now, the court we have a form here, and it's titled Judge's Explanation of Rights to Defendants Without Attorney. And at the bottom of this form, there are 5 choices. Now, if you want to reset your case to hire your own attorney, then you will put your initials on line 1. If your choice is I have hired an attorney whose name is, then you'll put your initials on line 2 and the name of the attorney on the line to the right. If your choice is I want to apply for court-appointed counsel, then you'll put your initials on line 3 to the left. If your choice is I have a court-appointed attorney whose name is, then you'll put your initials on the line to the left of the 4th line, and then you put the name of the attorney on the line to the right. If your choice is I want to waive my right to an attorney and represent myself, Then you'll put your initials on the line to the left. And then at the bottom of that document, once we conclude the arraignment, you can sign the bottom of the document and date it today's date. All right. Now, you also have a right to have a trial by jury. And what a trial by jury is, it simply means that you have a right to have 6 citizens from Jefferson County to listen to the evidence, and they will decide whether or not you are guilty or innocent. You also have a right to waive or give up your right to have a trial by jury and just have your case come before the court. If you come before the court for a trial, we call that a bench trial. If you come before the court before a plea, it's obvious we just call it a plea bargain or a plea or unagreed plea if you have not reached an agreement with the state. You also have a right to have witnesses to come to court to testify for you or against you. And witnesses sit in that chair over here to my left. That's called the witness stand. They can testify for you or against you. You have a right to ask them questions. We either call that direct examination or cross-examination. You also have a right to waive or give up your right to have witnesses to come to court in your case. Also, you have a right for what we call discovery. And discovery is you have a right to see the evidence that the state has against you. If you do not request discovery, if you do not want to see the evidence, you can waive, which means to give up your right to see the evidence that the state has against you. Now, if you would like to see the evidence or you request discovery, then the state would allow you to have access to that evidence that they have against you in your case. If you are not a U.S. citizen, on a plea of guilty or no contest or no contendere, it may result in deportation, which means you could get kicked out of the country, exclusion from admission, which means if you're outside of the country trying to come in, they can prevent you from coming in, or it may result in denial of naturalization. That simply means if you fill out an application to become a citizen, they could deny that application or deny your application. Now, for those of you who are representing yourself, you'll have an opportunity to talk to the prosecutor today. Now, if you have an attorney, your attorney will have an opportunity to talk to the prosecutor when your case comes up. And basically, they'll talk to you or your attorney to see if y'all can reach what we call a plea bargain agreement. And what a plea bargain agreement is, it's a settlement of your case. And if you do decide to settle the case, then we call that a plea bargain agreement. Now, that plea bargain agreement will come before the judge or the court, and the judge do not have to follow that plea bargain agreement. If the court does not follow the plea bargain agreement, then you'll be entitled to withdraw, which means to take back your plea of either guilty or no contest. However, if the court follows the plea bargain agreement, and if you decide within 30 days that you would like to appeal your case, and what an appeal is just basically having a higher court than this court to review your case. That higher court in this county or in this area is called the Ninth Court of Appeals. Actually, it's located right above us on the 3rd floor. They will review your case and they will decide either to grant or deny your appeal. If your appeal is granted, they can find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then within 30 days of them denying your appeal, you'll have a right to file what we call a pro se petition for discretionary review. And basically, pro se means you'll be doing it on your own without the assistance of an attorney, and you'll be asking a higher court than the Ninth Court of Appeals to review your case. That higher court is called the Texas Court of Criminal Appeals. They're located in Austin, Texas. They'll review your case, and they will decide either to grant or deny your pro se petition for discretionary review. If they grant your pro se petition for discretionary review, they can find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your pro se petition for discretionary review, then your conviction at that point will stand. The district attorney's office has a program that is called pretrial diversion. And what that program is, it's an opportunity for you to have your case dismissed. And the way it works is, you first of all, in order to qualify, you have to have an attorney to submit the application. It cannot be an offense involving unlawful carrying a weapon or resisting arrest. And you cannot have a criminal history. And so you cannot have a criminal history in the case. In essence, you can't. And so it has to be normally your first offense. Now, if you are able to get into the pretrial diversion program, the case will be dismissed and it will not result in a conviction on your record. Okay? Well, what will happen is you may qualify for what is called an expunction. Okay? And what an expunction is, it means that they will, with the expunction, they will, your case will be erased, deleted from your criminal history. Okay, if you qualify, if you get an expunction. And so therefore you would not have this here case on your criminal history. All right. But you have to get in the program and you have to complete the program in order to qualify for an expunction. All right. That's the pretrial diversion program. Now, the state has another program as well. That program is called Veterans Court. The Veterans Court program is also part of the pretrial diversion program. All right. And with the Veterans Court, if you are a veteran of any one of the branches of the United States military, you can qualify. And if you get into the program, complete the program, this case may result in an expunction as well. All right. So those are the programs that the district attorney's office has. Also, now I spoke earlier for the Class A and Class B misdemeanors. I said you could have your range of punishment either could be confinement or a fine. You may qualify for probation. There are two types of probation. One type of probation is called deferred adjudicated probation, and the other probation is called adjudicated probation. Okay, the difference between the two is adjudicated probation is what we usually call regular probation. And now it does result in a conviction in your record. However, there's something that is called judicial clemency, which means that the court can set aside the conviction. Now, the way it works, in order for you to qualify for judicial clemency, you have to successfully complete the probation. You cannot have any more time left on the probation, so the probation has to expire, and then you must successfully be discharged from the probation. If that happens, then the court can allow you to come back in the court to withdraw, which means to take back your plea of either guilty or no contest. And if that happens, then any complaint, affidavit, or information that has been filed against you may be dismissed. And if that happens, then you will no longer have a conviction. And you can truthfully say you were not convicted of this offense. However, if you get a subsequent or another conviction later on, then this case can be revived, resurrected, or brought back up and used against you. Okay? And if you try to get a license with, say, CPS, they can deny giving you a license, or if you have a license, they can revoke or suspend that license. Now, for the deferred adjudicated probation, it does not result in a conviction on your record. However, now, and if you successfully complete it, it does not result in a conviction on your record. However, If you violate your terms and conditions of your deferred probation, the state may file a motion to revoke your unadjudicated probation. And if they file a motion to revoke that deferred probation, then you can be arrested, brought back into court. The court can have a hearing. And if the court determines that um, you violated your probation, uh, the court can, kick you off probation and, give you a conviction. Now, and if you get a conviction, obviously that conviction is not going to be wiped off your record. And so therefore you won't qualify for what we call a dismissal, and you won't qualify for a non-disclosure. A non-disclosure basically is where we can't tell the general public that you were on probation for this offense, okay? So those are the things that those are options that you have and the rights that you have in your case. Now, this court has a program that is called, we call it the CSI program. It stands for our Community Safety Initiative. And that is a program designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, raise our families, go to church. And that program is designed to address what we call recidivism. Recidivism is where people commit crimes over and over. And so the way we approach that is we have partnerships with some of the agencies that's in our community. We have a partnership with Spindletop. Spindletop have a mental health program, and they also have a drug treatment program. We also have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. And Lamar University has a job training program that's called CICE. And with those partnerships, we are able to address some of the issues that plague the community. So we have people here in court. They're actually in jury and panel room, or the jury room. They are here from Spindletop. So if anybody have, say, for example, you have a mental health issue, they'll do a private interview. They'll do develop a treatment plan, do an assessment, develop a treatment plan for you as well. Now, if you have issue with drugs and alcohol, we can get some folks from what we call OZAR, our local drug and alcohol council, who can come and do a screening. They can develop a treatment plan, and they can do an interview as well for you. Also, if we have individuals who are unemployed, you're unemployed, do not have a job, through our partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the areas of the shipping industry, the hotel industry, or the chemical industry. So you get trained in one of those fields that you choose, and they will assist you with placing you on a job in that particular area. Now, if you do not have a high school diploma, I think Spindletop as well as CICE has a GED program to assist you to get your high school diploma. All right. Now, also, all of those programs that I just spoke of do not cost you anything. They're free. And the only thing you would have to say is, well, I want to, participate in one of those programs. Now, the other thing is this: all of those programs can be used toward what we call punishment. Now, for example, if you have been, and I'm sure everybody here has been arrested on their case, and so you served some time in jail and then you bonded out. But every day that you spent in jail, that can be used as credit toward your sentence. So for example, let's say you spent 5 days in jail, and let's say the state is offering you a a fine and court costs of, no, the state is offering you 5 days in jail. If they're offering you 5 days in jail, then that means that you won't have to serve any more time in jail because you've already served 5 days in jail. So you get credit for time served. Now, if they offer you a fine plus court costs, every day that you spent in jail, you get credit at $100 per day. So if you spent 5 days in jail, that's $500. So if they offer you a fine and court costs that equal $500, that means that you won't have to pay anything. Why? Because you've your fine and court costs has already been paid, is basically been paid off for the time that you spent in jail. So your fine and court costs will be what we call taxed and retired. So you won't have to pay it now. If you have less time in jail than what they are offering, then you have to either serve the rest of the time or pay, if it's a fine and court costs, pay whatever that balance is. Now, if you cannot pay the balance, let's say you got offered a fine and court costs, but you can't pay it, then we can put you, if you can't pay it right now, we could put you on a payment plan so you can pay it off over time. Or let's say because of your financial situation, you can't pay it off at all. Then we can convert your fine and court costs to what is called community service. So you can work that off. And so you get credit at $12.50 per hour for every hour of community service that you work, and it will go toward your fine and court costs. Now, let's say you're in one of the programs that I spoke of. Let's say you're in the job training program, or let's say you're in the mental health program, or the drug program, or the alcohol treatment program. If you're in one of those programs can actually be used as community service. So that simply means, I tell people this all the time, you can kill two birds with one stone. Well, actually, three birds with one stone. And the way it works is like I said, you ought to pay a fine and court costs, but you don't have the money to pay the fine and court costs. They convert it to community service. That's the second thing. And you're in a program, let's say you're in a GED program. While you're working on your GED, that GED is going toward, every hour you're in the program, it goes toward community service. And every hour that community service is $12.50 that goes toward your payment of your fine and court costs. And it's the same thing if you're in the drug program or the alcohol program or the mental health program or the job training program. So if you're being trained for a job, every hour you're in that class is converted into community service, an hour toward community service, and $12.50 will go toward your fine and court costs. So that's the way it works. And so I tell people this all the time, is that with our program, we don't just arrest the problem, we try to address the problem that are plaguing the community, okay? Through our CSI program, Community Safety Initiative. Now, what we're going to do is the bailiff handed out some forms to you. And that form was what I read off earlier, which is called the judge's explanation of rights to defendants without an attorney. And on that form, you have three choices. You can say you want to hire an attorney. If you do so, that case, your case will be reset to give you time to do that. That's the first choice at the bottom. The second choice at the bottom, if you want to hire, if you already have an attorney hired, you'll put your initials on the second page and the name of the attorney to the right of that form, on the second line to the left, and then you put the name of the attorney on the right. Now, if you want to apply for court-appointed counsel, you'll put your initials on the third line, and we have some financial, well, actually, we'll send you over to our pretrial office, and they'll have you to fill out a financial questionnaire, and then we'll look at it to see whether or not you qualify for an attorney. And if you have a court-appointed attorney already, then you just put your initials on the line, the fourth line to the left, and the name of the attorney on the line to the right. Now, if you want to waive your right to an attorney and represent yourself, then you will put your initials on the line, the fifth line to the left, And then once you do that, we have some waivers that we'll go over with you. And once we do that, once you make your choice as to 1, 2 through 5, then you'll put your name at the bottom and date it today's date.